So I'm joined now by my partner, Ben Mason, and he's the head of the Shrewsbury employment team. Hi, Ben. Tell us a little bit about what's going on in Shrewsbury and the growth of the team at the moment.
Hi, Helen. So in the Shrewsbury team, we've got myself and Tori Shepherd, and Tori joined us near the end of last year. So we've grown from when I became a partner last year, and we're taking that forward and growing the Shrewsbury office. We've seen a lot of growth in the last 6 to 12 months, especially since obviously with lockdown, dealing with furlough queries, and we've got a lot more tribunal cases coming through as a result of some of the furlough and coronavirus epidemic matters.
That's great. And so today you're going to talk to us about IR35, and I know that's your specialist topic, so I'm going to let you take it from here.
Thanks, Helen. So we covered this topic in our last Employment Law Roadshow in March 2020. The changes were set to take place in April 2020, but in light of the pandemic, the reforms were delayed until April of this year. There have been many businesses have been calling for the changes to IR35 to be delayed further, but at the time of presenting this, it's set to be implemented in April 2021. So IR35 was introduced in the UK in the early 2000s in an attempt to tackle tax avoidance when an individual supplied their services through an intermediary such as a personal service company to avoid paying income tax and national insurance contributions. What the legislation is trying to prevent is where the individual in question would have a working relationship with the engager, reflecting that of an employer-employee, but instead they treat themselves as a self-employed so that they do not have to pay income tax and national insurance contributions, and instead they pay themselves dividends through their personal service company. Not only is this type of arrangement beneficial to the individual because they will earn more money than they would if employed directly by the engager, but it's also in many cases beneficial to the engager as it will not have the issue of employing the individual or paying employer national insurance contributions. Many engagers, such as the BBC and ITV, have requested individuals set up a personal service company so they would not be found liable for tax if HMRC did not feel the relationship between the individual and the engager was of a self-employed nature. As in such a scenario, the personal service company is liable to tax the income as employment income. Individuals who've recently lost cases against HMRC in these situations include Eamon Holmes of approximately £250,000 and Krista Ackroyd. So what is the reason for the reform? Well, in the private sector, the current position is that the burden of assessing and determining the individual's employment status for tax purposes falls on the individual supplying their services through their personal service company. Currently, there are no obligations on the engager to assess and no tax liability on them in this scenario. The practical challenge for HMRC is enforcing the legislation and requirement to police the thousands of PSCs responsible for applying the regime through self-assessment. Government estimates that only 10% of personal service companies are applying the IR35 rules correctly or at all, at a cost of hundreds of millions to the government. In the public sector, engagers have been responsible since 2017, which has brought in a lot of money to the government's coffers. So from 6th of April 2021, all medium or large size private sector clients will be responsible for deciding the worker's employment status. It will no longer be the responsibility of the PSC in this scenario. The burden will be on the engager to assess and determine the individual's employment status for tax purposes, and if the fee payer, to pay the personal service company accordingly. As a result of this, the engager will also be the one liable should HMRC deem the tax calculations incorrect. So in the cases I mentioned, the BBC and ITV would be liable for determining the tax status of the individuals under the new rules and would have had to pay the tax. When a deemed employment relationship exists, the entity paying the personal service company, the fee payer, will be responsible for operating PAYE and national insurance contributions on payments made. This may be the business who the individual is ultimately providing services to, the engager, or where the engage contracts with an agency, then the agency will be responsible for operating PAYE, and national insurance contributions based on the engager's determination to whether IR35 applies. Again, no liability on the personal service company to check employment status. Payment is based on the engager's determination on the individual's employment status as to whether IR35 applies. The new legislation only applies where the engager is a medium or large company. Small companies are exempt. So to classify as a small company and be exempt from the legislation, a company must meet at least two of the following criteria: the annual turnover of 10.2 million or less, 5.1 million on your balance sheet or less, and 50 employees or less. If your business does not meet at least two of these criteria, then they will be classed as a medium or large size business and the legislation will apply. LLPs and unregistered companies have the same classification as registered companies and are subject to the same criteria. For a group company to be a small company, its parent must qualify as a small company. The figures from all members of groups are aggregated. This is something to be careful of when reviewing whether the regulations apply to your business. Sole traders and other partnerships are based solely on turnover being less than 10.2 million, and if it is, they are a small company and the rules will not apply to them. When talking about the small company exemption, this only applies to the engager and not to any agency. So what happens where there is more than one party in the supply chain? Should there be any parties in the supply chain between the engager and the PSC, such as an agency, it is still the responsibility of the engager to assess and determine the employment status. The agency then becomes the fee payer. The engager is then required to pass the outcome of their assessment down to the company paying the fees to this personal service company, which would usually be the agency. If an engager comes within the small company exemption, then the personal service companies remain responsible and liable. Under the new rules, engagers will have the burden to assess and determine the individual's employment status, notify the contracting party of such status, then operate payroll if they are the fee payer, and make deductions for income tax and national insurance on the fee paid for service, and pay national insurance employer contributions if also the fee payer. It is likely that now the liability will lie with them, many engagers will take a cautious approach to making the determination and may even place many individuals inside IR35 where it is not otherwise obvious to ensure that the risk of tax does not lie at their door. In order to show compliance, the engager must do a number of things. They must determine whether, if the services were provided under a contract directly between the engager and the worker would be regarded for income tax or national insurance contributions purposes as an employee of the engager. To make such a determination, an engager needs to apply the employment status case law to decide whether the hypothetical contract would be a contract of employment using the usual factors from tax status case law, such as whether there's mutual obligation, personal service and the right to substitute, a matter of control, and other factors which include restriction on right to work for others, financial risk and the basis of payment, being integrated into the business, using their own equipment, and employee type benefits. Once a determination is made, the engager must issue a status determination statement which sets out the status determination and the reasons for reaching that determination. This must be given to the worker and the entity with which the engager contracts. And if the engager fails to do so, it will be treated as the deemed employer. The engager must take reasonable care in making its status determination. If it fails to do so, the engager will be treated as the deemed employer. Taking reasonable care may include using the HMRC CES tool, which is an online questionnaire which the engager can complete to help make the decisions on the status determination. It is important that the engager has processes and procedures in place to comply with the legislation. A worker or fee payer can dispute the engager's decision at any time before the final payment is made by making representations to the engager that the engager's status determination is incorrect. The engager must respond within 45 days, beginning with the date the engager received the representations, either confirming its original determination and giving reasons, or reversing its original decision and giving a new status determination statement. The engager must take reasonable care in reaching its new status determination. Fee payers in these scenarios will have the added costs of paying employer national insurance contributions when operating PAYE for the contractor, and with this will also come with increased admin and payroll costs. However, classification of an individual as a deemed employee for tax purposes will not automatically confer any employee rights on the individual, such as holiday rights or rights of unfair dismissal. For the individual to be deemed to be an employee of the engager for employment rights purposes, there would effectively need to be an implied contract between the individual and the engager. In order to prepare for the new rules, engagers and agencies should do the following: conduct a full audit and review of their business relationships with any contractors that they engage with in order to consider and determine whether any of these will be subject to the legislation. If contracts exist, consider whether they are a true reflection of the working relationship. If they're not, consider redrafting them to ensure that they're more accurate. Contact the relevant contractors to discuss the determination of their employment status so that you can iron out any disputes in relation to this prior to the legislation coming into force. Prepare and update payroll and HR systems for a potential change in the way you need to pay contractors. And prepare and budget for the increased costs potentially involved in order to take account of the tax to be paid. So once you've undertaken your audit, identified the workforce affected and clarified the working relationship, it is then to make commercial decisions as to how the rules affect the business and how you can commercially prepare for the legislation. This may include including indemnities in commercial contracts with your supply chain and including clauses in relation to the status determination process and any appeal process. An engager or fee payer may want to bring to an end current arrangements prior to the new rules coming in and renegotiating these terms, as they may suffer from additional costs that would not previously have been foreseen, such as admin costs and employer national insurance contributions that would not have been factored into the current arrangements. Contractors who may be determined to be inside IR35 may look to increase their fees to ensure that they're no worse off now that their fees are subject to PAYE. Agencies will also look to see how they can recoup their losses if they become the fee payer. They may wish to increase the costs to the engager or simply not use contractors who provide their services through personal service companies. All those in supply chains may reconsider how they contract with others and on what basis. For example, engagers may wish to request that contractors no longer use personal service companies and instead contract through umbrella companies or agencies that apply PAYE. Engagers may wish to simply reduce the risk of an individual being deemed to be employed by taking them on a fixed-term contract of employment basis, which comes with additional risks. Of the contracts between the parties, the contract with the engager is likely to get more attention in any HMRC investigation. In order to limit the risk of an arrangement falling inside of IR35, the following should be considered. Include a right of substitution, avoid an obligation to accept and provide work, avoid or minimize restricting the worker's right to work for others. The worker should be subject to as little control as possible. Contracts should, if possible, be structured by reference to completion of a project or piece of work rather than by its duration. The worker should not be integrated into the engager company more than is absolutely necessary. If possible, require the worker to provide their own equipment rather than providing this to them. Although not determinative, it is still helpful to state in the contract that the relationship is not intended to be one of employment. Of course, all of these points need to be weighed against the commercial requirements of the contract in question. However, if the situation does require, for example, an obligation of personal service, then it should be appreciated that this may bring some IR35 risk with it. The relative negotiating strength of the various parties is likely to influence the decision as to whether the contracting arrangements and/or payment terms can or need to be revised. If businesses get it wrong, then they may have payment notices issued by HMRC in respect of national insurance and tax, late payment fines, and large penalties issued against them. One final matter that has been of concern for individuals providing their services through intermediaries is whether HMRC would use a deemed employment status determination to open retrospective compliance checks under the IR35 rules. HMRC has committed not to do so unless HMRC suspects fraud or other criminal behaviour. Thank you.
Okay, so thanks for covering all of that, Ben. So it is quite a hot topic, isn't it, at the moment? And it's really something that those who consider themselves self-employed really need to take a look at, or consultants, as you've been saying through your presentation. Any other top tips that you think we should be taking away today?
It's really doing as much as you can as soon as possible. And one of the things really is to start auditing who in your supply chain you need to look at in respect of IR35, and being able to get those people out, especially bigger companies, being able to see where those gaps are, and then implementing the processes that need to be done.
Well, that's great. And it's great to hear that things are going so well in the Shrewsbury office. So thanks very much for joining us today.
Thanks, Helen.
Thank you.